In this video, I'm going to be explaining, as a criminal defense attorney, how to get the best outcomes in domestic violence cases. My name is Veronica. I'm a domestic violence defense attorney here in California, and I help people put their cases behind them so that they can enjoy their lives and their freedom. And again, in this video, I'm going to be explaining 5 things that I do to get great outcomes in domestic violence cases. The first thing that your attorney should be doing in a domestic violence case, if you hire them before your first court date, is talking to the DA, sending over a mitigation packet, which is basically a character packet, explaining all of the good things about you, hardships you've experienced, if you have letters, character letters, submitting those, if you've been going to therapy, domestic violence classes, anything like that. That should be submitted by your attorney to the DA before court. It's really important for the DA to know that you have an attorney, you're fighting this, you're not just going to take the first deal, and to hear all these good things about you. Maybe even submitting your side of the story or a letter from the alleged victim if they don't want to prosecute, explaining that they don't want to prosecute. And I mean, the letter from the victim is not determinative, but it can help, because before your first court date in a domestic violence case, the prosecutor still has to look at this case and decide if they want to file more serious charges than what you were arrested for, less serious charges, or drop the case altogether. And one of the reasons why this video is specific to domestic violence cases is, let's say that you're charged with murder, or it is your second strike and it's an armed robbery of a 7-Eleven. We're not probably going to be sending over letters to the prosecution asking them not to file the case, because they most likely are going to file. But domestic violence is one of those types of cases where the police make an arrest first without doing much investigation. You know, if you rob a 7-Eleven, they're probably going to look at their surveillance video before they arrest you, unless they catch you red-handed. So they arrest you without doing much investigation. And there are so many arrests for domestic violence that if the prosecution wants to prosecute people who are robbing the 7-Elevens, they cannot possibly prosecute everybody who is arrested for domestic violence. So it's so important to contact them early and try to maximize the chances that your case will end up in the pile of cases that do not get filed. And I've been doing this now for about 11 years. I used to handle much more serious cases primarily. So I would handle cases all the way up to first-degree murder trials, a lot of gang cases, etc. And the process really is different. And sometimes people call me and they have an attorney who does what I used to do and who doesn't do a lot of domestic violence cases. And they tell me, well, my attorney said that we should just wait for the first court date and see if they file charges against me. Or my attorney wants to review the police report, which you don't get until the first court date and only if they file charges against you. My attorney wants to review that police report before they submit my side of the story. Okay, if it's a murder case, yes, for sure. If it's a robbery case, yeah, probably. But domestic violence is different. So you really need an attorney who handles these domestic violence cases routinely and not somebody who just handles general criminal defense. I mean, even if you have an attorney who handles primarily more minor cases, DUIs, for example, the process for DUIs is totally different than domestic violence. So it's important that they take this action, that they contact the DA before court, that they do everything possible to try to get the case dropped before court, because that is the best possible outcome that you can get in one of these cases. It's better than the time and expense and stress for, whatever, 6 months to a year before you get to trial, of going to trial and winning. It is a better outcome. And so, number 1, contact the DA before court. Number 2, it's really important to create a plan for your client early on. I mentioned going to therapy or domestic violence classes. Actually, I had a case today. We're in September of 2023. This is a case that started in January of 2023. And this was a second offense on my client's part. It had already been filed by the time I got the case. So I told my client immediately, I need you to go to these domestic violence classes. And he didn't like it. In fact, he was not that happy with me that I was recommending that he go to so many classes. He keeps asking me, can I stop going to classes? Can I stop going to classes? The deal that he had on the table before he hired me for the case was a significant amount of jail time. Ultimately, I was able to get the case. And ultimately, even though the evidence against him is strong, I was able to get him a non-jail offer. And I will tell you that the DA, when the DA was giving me this deal, what they told me is, I can tell that he's serious about this. I can tell that he is really putting in effort because he's gone to so many classes. So now he's happy with me. But it's really important to do that early on, because what if he had waited until August and then he started the classes? Well, now he's only gone to a few of them, right? But it was the number of them and the fact that over months, he had proven himself. He'd proven that he would continue to go to these classes, begrudgingly, but he would continue to go to them, and it saved him. That's what saved him ultimately. Now, if I hadn't told him to go to those classes, he would have no way to know. So it's really important for your attorney to tell you early on, hey, here's what I want you to be going to. Start going now. Maybe it won't be necessary. Maybe we'll get it dropped before court and you can stop going then. But I want you to start going to them early on. Number 3, I think something you should look for in an attorney is be nice, but don't be a pushover. And I'm talking about when you're talking to the DA. Sometimes I'll approach a DA and they're having a bad day, or that's just how they are. They're incredibly grouchy. And sometimes, especially, look, you don't go into law because you are friendly, typically. Most of us kind of want to fight, right? I mean, that's why we did this. That's why when we were little kids, maybe our parents or our teachers told us, maybe you should be a lawyer. But it's really important that your attorney is able to keep their cool. And if the prosecutor is grouchy, just be nice. I would say relentlessly nice. I'm not saying relentlessly be a pushover. I know some people think when they're hiring an attorney, I should hire a shark. I should just hire this guy he's loud, he's mean, he's going to be intimidating. But I don't think that is helpful because the DAs have a lot of discretion. And sometimes for domestic violence cases, you're going to have a female DA who really wanted to work on domestic violence cases. They requested to prosecute domestic violence cases, right? They're not doing that because they want to give defendants a break. And then you have this big, brash, aggressive man who's coming up to them and being mean, or who is giving in to the urge to be argumentative and rude. And that, in my experience, is not the way to get a good deal. Now, also, especially if you're a new attorney, it's really important not to be intimidated or be meek. You have to just be confident, the system is what it is, and just be relentlessly nice, relentlessly kind, while still always advocating for your client and always showing in everything that you say when you're in the courtroom that you care about your client. Number 4, it's really important to be persistent, to not give up. I've taken over plenty of cases where the client previously had another attorney, now they have me. And the DA had given them an offer that obviously they don't want and told them this is my last best offer. I've had cases where I was representing them the whole time and the DA gave me an offer that I wasn't happy with, my client wasn't happy with, and they said this is my last best offer. Sometimes that's true. But what's important is to not give up, especially if I can look at the case and think, look, I've had similar cases where I was able to get a much better result than this. Let me keep trying. Let me go to another court date. Let me talk to the judge in chambers and have them put the pressure on the DA. How about if I set up a meeting with the DA's supervisor and see if I can get a better deal there? Many times we can. Maybe I should send my client to another type of class. I'm not kidding. Do something to change it up. And don't just give up, especially if it's something that is potentially going to ruin my client's life. It's important to be very persistent. And some of those cases that I've taken over, when the DA told the defense attorney, this is the last best offer, the DA just went to the client and said, this is the last best offer. And they were wrong. It takes persistence. And it can be difficult when you're the one accused of this and you want nothing more than to get this whole thing resolved. And it's stretching out for another court date, another court date, another court date. But what you have to understand is that part of what the DAs want and what the judges want is to close cases. They can't, if they have cases where you keep coming back to court again and again and again, if that happened with all of the cases, then soon they would be so overloaded, they would have thousands of cases per day, and they wouldn't be able to prosecute really anyone. They wouldn't be able to do a good job with anyone. So part of their goals, and same for the public defender, is to close cases and quickly. But when you have a private defense attorney, you can afford to be persistent. We can go back to court 10 times. It doesn't matter. Part of my job is not to close cases quickly. My job is to get the best possible result for my client. And when we're the squeaky wheel and they're like, oh, you're back here again. You know what? We don't have an answer for you. Why don't you come back next week? And they're expecting me to say, no, I don't want to come back next week and try to put pressure on my client. But instead, I say, okay, I'll be here. No problem. Let's come back next week. Maybe we can get a better deal then. Maybe you can have some time to review this new information that I've given you and we can get a better offer then. Number 5, build a great reputation as an attorney who does go to trial. Because I've been talking a lot about deals. I've been talking about the DA voluntarily dropping the case. But there are a lot of defense attorneys who don't go to trial. The DA's office knows who goes to trial and who doesn't. Many attorneys will never go to trial. They just don't. They're settlement attorneys. And the DA knows basically what the DA can do is call their bluff, because the threat on both sides, the threat to the DA and the threat to the defendant, is that the case will go to trial. And in the trial, there will be a winner and there will be a loser. And there's some middle ground when there are multiple counts, but typically there's going to be a winner and there's going to be a loser. It's going to take a lot of time and it's going to be expensive. But if the DA already knows your attorney is not going to go to trial, or your attorney might go to trial but they suck and it's not going to be hard to win against them, then you automatically lose leverage. So it's really important as a defense attorney to take some cases to trial and to do an excellent job at trial. I was lucky that I was able to build that reputation very quickly, because when you take on really serious cases like first-degree murder cases, third-strike cases, and especially when you win them, the DA's office knows who you are. So then when you come in and you're like, I just beat you guys last week at an attempted murder case that you guys thought you were going to win. You wouldn't offer me anything less than 15 to life, and my client walked. And now I have a domestic violence case, and I'm just asking you, look at all the classes he's done and dismiss it. Your evidence isn't that strong, and you know I'll take it to trial. Now I have a much stronger case than if I'm a settlement attorney, and they know I never go to trial. I hope you found this video helpful. I think one of the key takeaways here is you can have two defendants accused of the exact same thing, but depending on what your attorney does and what you do, because if you're a criminal defendant, you do have some control over your case, you can have two wildly different outcomes. You can have one where you end up with a felony conviction and jail time, and you can have another one where the case is dismissed entirely and you have a clean record, depending on what path you take. So I hope that this video helped you find the right path. And if you do have a criminal case in California that you need help with, feel free to set up a consultation. You can find a link in the description box down below. You can also find my phone number there.